Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. We will conduct a question-and-answer session during the conference. To request to ask a question, please press *1. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I will now introduce your host for today's conference, Ms. Janice Wingo with the International Trade Administration. You may begin.
Good morning and welcome to today's IP webinar. Today we're very lucky to have with us Dr. George Chan, who is a practitioner with Rouse in Beijing. And today Dr. Chan is going to speak to us on how the Chinese courts define the scope of protection for well-known marks. Before Dr. Chan jumps into his presentation, I wanted to remind you that that this presentation is actually being recorded, and that those who have any questions of Dr. Chan may email him. Those listening to the recording can email him as well. Dr. Chan has an LLB degree from the University of Ottawa in Canada, and then a PhD degree in experimental medicine from McGill. Prior to joining Rouse, he was a partner at a boutique IP firm, and at Rouse he has extensive experience in assisting international clients with IP matters, including patents, trademarks, copyrights, and IP strategy, particularly the acquisition and enforcement of intellectual property rights. We're very lucky to have George with us today, and we look forward to what he has to say about well-known marks.
Thank you very much for your introduction, Janice. I guess the starting point for this talk is that China, as a signatory country to the Paris Convention and the TRIPS Agreement, provides extended protection to well-known marks in accordance with their international obligations. This is codified under Article 13 of China's Trademark Law. Article 13, Section 1 codifies the rights afforded to unregistered well-known marks, such that where a mark is a reproduction, imitation, or translation of a third party's famous trademark, which has not been registered in China, and where the goods are identical or similar, which may cause public confusion and damage the interests of the registrant of the famous mark, no registration shall be granted, and use of the mark shall be prohibited. Article 13, Section 2, on the other hand, codifies the rights afforded to registered well-known marks, where a mark is a reproduction, imitation, or translation of a third party's famous trademark, which has been registered in China, and where the goods are not identical or dissimilar, which may mislead the public and cause injury to the interests of the registrant of the famous trademark. No registration shall be granted, and the use of the mark shall be prohibited. Where owners of well-known marks in the past, during the early opening up and market reform period of China, we found that Article 13, Section 1 of the Trademark Law was relied upon more heavily by trademark owners looking to prohibit third parties from registering or using their well-known marks in China. In recent years, we've seen that owners of well-known marks are now not as dependent on Article 13, Section 1 of the Trademark Law, as most well-known marks have already been registered in China. Their pain points now are where they are facing greater challenges is dealing with bad faith applications or registrations by third parties for their well-known marks that are directed towards dissimilar goods and services. We are therefore seeing more reliance on Article 13, Section 2 of China's Trademark Law, which provides owners of well-known marks with a legal basis for dealing with this type of activity. Essentially, Article 13, Section 2 of the Trademark Law expands the scope of protection for well-known marks so that they cover additional goods or services not listed on their trademark registration. Now, in spite of this growing reliance on Article 13, Section 2 of the Trademark Law, the test to obtain extended protection had been in the past laid out in very vague terms, with very little guidance provided by the courts or the China Trademark Office. More specifically, if we look at the very last portion of Article Section 13.2, which may mislead the public and cause injury to the interests of the registrant of the famous mark, no registration shall be granted and the use of the mark shall be prohibited. This has been, for the most part, left open to interpretation on a case-by-case basis. The State Administration of Industry and Commerce, which oversees the China Trademark Office, issued the Trademark Review and Adjudication Standards in 2005, which provided some conditions for the applicability of Article 13 of the Trademark Law. That is, the trademark must be registered in China and is already well known before the date of application for the registration of the trademark in dispute. The trademark in dispute constitutes a copy, imitation, or translation of the well-known mark. The service or products represented by the trademark in dispute are not the same as or highly similar to those represented by the well-known mark, and the registration or use of the trademark in dispute may cause confusion to the public recognition and thereby damage the rights and interests of the registrants of the well-known mark. However, when looking at these, you see that for the most part, these regulations recite the trademark law, which I reproduce for your reference at the very bottom, such that it's a minimal, it really provides very little guidance to practitioners and trademark owners, such that all we really see is basically almost an confusion being equated with misleading. Now, this has pretty much been the status quo from 2005 until 2009, when the Supreme People's Court started to take a more active role in defining this area of the law, such that the Supreme People's Court noticed that in some cases there were parties that were abusing the well-known trademark status system in China for material and commercial gains. And by taking steps primarily by issuing two legal instruments. The first relates to civil litigation, that is, the interpretation of several issues regarding application of laws and protection of well-known trademarks in trademark-related civil disputes. The second relates to administrative litigation, and that is the opinions of the Supreme People's Court concerning the trial of administrative cases in respect of trademark rights granting and confirmation. Now, Article 9, Section 2 of the Supreme People's Court interpretation provides clarification for that portion of Article 13, Section 2, which I raised earlier. Misleads the general public and leads to possible damage to the interest of the registrant in that famous trademark. More specifically, Article 9, Section 2 of the Supreme People's Court's interpretation breaks down this part of Article 13, Section 2 of the Trademark Law, so that misleads the general public is understood to be there is a certain connection between the trademark against which the lawsuit is lodged and the famous trademark, and the portion leads to possible damage to the interest of the registrant of that famous mark is to be understood as the distinctiveness of the famous trademark is diluted and the market reputation of the famous trademark is degraded, or the market reputation of the famous trademark is improperly utilized. Article 10 of the same interpretation lists the factors that the court should consider when applying Article 9 of the interpretations to a particular case. The first is the distinctiveness of the famous trademark. The second is how well the famous trademark is known by the relevant general public that uses the commodities using the trademark against which the lawsuit is filed. The third is the connection between the commodities using the famous trademark and the commodities using the trademark against which the lawsuit is filed, and other relevant factors. Now, the Supreme People's Court opinions, Article 10 provides the basis for application of the test that is found in the interpretation to administrative disputes, and that is the granting or affirming of trademark rights. Article 10 provides that when hearing administrative cases on granting and affirming trademark rights of well-known trademarks, the People's Court may refer to relevant provisions such as Article 5, Article 9, and Article 10 of the interpretation on several issues concerning the application of law in trials of civil dispute over well-known trademark protection. Now, having laid out the current state of the law, interpretations, and opinions to illustrate how these are applied by Chinese court in determining the scope of protection for well-known marks, there are two cases that I'd like to share with you. The first is Shanxi Xinhuacun Winery Company and the Trademark Review and Adjudication Board. The second case is Inner Mongolia YILI Industrial Group Corporation and the Trademark Review and Adjudication Board. first case involving Shanxi Xinhuacun. Shanxi Xinhuacun Winery Company is the manufacturer of the Chinese wine Xinhuacun, and Shanxi owned 2 prior trademark registrations for Xinhuacun in Class 33 for white wine and beverages, not including beer. In 2002, Anhui Xinhuacun, referred to as Anhui, filed a trademark application for Xinhuacun in Class 31 for forestry products, grains, plants with seeds, brewing malt, etc. Shanxi opposed Anhui's application on the basis that the registered Xinhuacun mark was already well known, and therefore this was entitled to a scope of protection that precluded others from registering Xinhuacun for forestry products. At the opposition, the China Trademark Office was of the opinion that Shanxi Xinhuacun trademark was not entitled to well-known status and therefore approved Anhui's application for Xinhuacun. And in doing so, they applied a test which considered the popularity of the prior mark, the originality of the prior trademark, and the relatedness between designated goods of the disputed trademark and those of the prior trademark. In this case, Shanxi appealed the CTMO decision to TRAB, and TRAB varied the China Trademark Office decision slightly. Thereby, TRAB decided that Shanxi's registered trademark Xinhuacun was well known with respect to white wine. However, they only expanded the scope of protection for this well-known mark slightly, so that it would also cover similar goods to those listed on the Shanxi Xinhuacun trademark registration, and in doing so, they removed brewing malt from the Anhui Xinhuacun's registration, as brewing malt might be considered similar to white wine. So Shanxi further appealed their case to the Beijing No. 1 Intermediate People's Court, which upheld TRAB's decision. And in doing so, they cited the same reasons that TRAB did. That was the word Xinhuacun was not originally created by Shanxi. There's significant differences between the goods approved for Shanxi's Xinhuacun mark, that is white wine, and the designated goods of the disputed trademark, that is forestry products and grains, with respect to the mode of production, the sales channels, and relevant consumers. In addition, they held that the registration and the use of the disputed trademark for forestry goods and grains would not mislead the relevant public nor lead to economic loss for Shanxi. So Shanxi, not satisfied with this, the results of their appeal, filed a second instance appeal to Beijing's higher People's Court. And on appeal, their main argument was that the standard that the original decision adopted by the Intermediate People's Court and TRAB was inconsistent with the test outlined in Article 9, Section 2 of the Supreme People's Court interpretation. That is, the test adopted by TRAB and the Intermediate People's Court considered the popularity, originality of the prior trademarks, and the relatedness of the goods between the disputed trademark and those of the prior trademark. The intermediate court's focus on this concept of originality, or the creation of the mark, the word Xinhuacun, led the court to ignore the distinctiveness of the Xinhuacun mark belonging to Shanxi. So, on appeal to the higher People's Court, the key issue that the court had to address was, what is the correct test for identifying the appropriate scope of protection for Shanxi's well-known mark? In this case, the court held that the appropriate test is laid out under Article 9, Section 2 of the Supreme People's Court interpretation, which stipulates the circumstances that are enough to bar the use and registration of a mark that is a copy, imitation, or translation of a well-known mark directed towards dissimilar goods. That is, where it is sufficient to make.
And excuse me, this is the operator. It looks like our leader disconnected. One moment while I reconnect.
Hi, this is Janice. Since we have a technical difficulty, can I just take a moment to remind the listeners that there will be 2 webinars next month in October. The first one will be on October 11th. That is a webinar on protection of your marks in trade fairs. And then there will be a webinar 1 week later on October 18th. That is on licensing your trademarks. These are both by practitioners in China. This is Janice. We apologize for the technical difficulties. The presenter, his line got dropped off. You don't have a problem. Your dial-in is good. Unfortunately, that his line to Beijing got cut. He will be dialing in again, and we will resume the webinar in about 2 or 3 minutes. While I have you on the line as a captive audience, I also wanted to plug for the stopfakes.gov website. The stopfakes.gov website has a China toolkit along with toolkits for other jurisdictions where you can learn about IP rights in those jurisdictions. Also, all the webinars, past webinars, there's an audio recording of these webinars. It's free. You can get on and listen to any webinars that you may have missed. And most of the participants have said that they would welcome questions. So if you have any questions for the presenter, you can email that presenter and ask her those questions.
And we have George Chan back.
My apologies. I believe my call was dropped from a landline. I believe I was informed by the moderator that I dropped off about 2 slides ago. So I'm just going to continue from the point of where the application of the test for determining the scope of protection for well-known marks, and more specifically, just looking at the 4 factors that the court will look at. The first being the distinctiveness of Shanxi's Xinhuacun mark. And in this case, the High Court acknowledged that the mark was well known with respect to also acknowledged that the Trademark Review and Adjudication Board and the First Instance Court were correct in that Shanxi did not coin Xinhuacun. So this being the case, in the view of the High People's Court, this concept of inherent distinctiveness will not usually play a role in determining the scope of protection for well-known marks, such that their belief is that a well-known trademark will have a very high level of distinctiveness because it's widely known amongst the relevant Chinese public. And this being the case, whether it's an inherently distinctive trademark or not will not have much of an effect on its scope of protection ultimately. The second consideration that the court looked at was the relatedness of the goods bearing the Xinhuacun trademark and those bearing the disputed trademark. And in this case, Shanxi's Xinhuacun mark was approved for use on alcoholic beverages, which is significantly different from forestry products and the like in terms of production mode, sales channel, target customers, etc., where the court had an issue with this concept of inherent distinctiveness is with respect to the public awareness of Xinhuacun amongst the relevant public that would consume or purchase forestry products. That was, Xinhuacun was not created by Shanxi, and it was actually coined by a very famous Chinese poet from the Tang Dynasty named Du Mu. And in the court's opinion, if Anhui used the disputed trademark for trees or grains and other similar commodities, part of the relevant public would possibly associate Xinhuacun with Shanxi. However, in their opinion, they would more likely associate with Du Mu. In addition to this, when they looked at other relevant factors, this case is distinguishable from earlier cases on the basis that this decision appears to turn on the policy rationale outlined by the Beijing Higher People's Court, such that by providing Shanxi's registered Xinhuacun mark with too wide of a scope of protection across too many goods, this would be unfair to other commercial operators looking to draw on the historical and cultural goodwill of Xinhuacun as a word. In the words of the court, what's worth mentioning is that others should not be prohibited from obtaining, choosing, and setting up their own trademarks from the same public resource. Du Mu's verses, so long as they do not cause injury to the interests of Shanxi Xinhuacun Company and their prior trademark. So, in this case, the Higher People's Court agreed with TRAB and the Intermediate People's Court, such that they found that the current circumstances did not fall within Article 9, Section 2 of the Supreme People's Court interpretation, such that, in their eyes, or in their opinion, a certain connection between the trademark against the law, which the lawsuit is lodged, and the famous trademark did not exist. Accordingly, Anhui Xinhuacun's mark was accepted for registration with respect to forestry goods in Class 11. The second case, which I'd like to share with you, is the YILI case involving Inner Mongolia YILI Industrial Group Corporation and Trademark Review and Adjudication Board. In 2000, the year 2000, Wenzhou City Longwan Haichang Hechang water heating store filed a trademark application for YILI in Latin characters and YILI in Chinese characters, using the exact same Chinese characters as that of the Inner Mongolia YILI mark, to be used in association with hydrants, bath fittings, sanitary apparatuses, and installations. YILI Corp opposed the applications based on its prior trademark right for YILI, claiming that its mark had been registered and recognized as well known by the China Trademark Office in the year 1999 as being a well-known mark, and that their prior registration was entitled to a broader scope of protection, which covered other parties' use of the YILI mark with goods in Class 11. In support of their claim, YILI Corp filed evidence that YILI and its owner, YILI Corporation, are both well known with respect to dairy products. YILI Corporation produces over 1,000 YILI branded products, including popsicles, ice cream, milk powder, and similar goods. And also that YILI Corporation was the exclusive provider of dairy products for the 2008 Beijing Olympic Games and the 2010 Shanghai World Expo. In January of 2005, the China Trademark Office approved the applications for the YILI marks, such that, in their opinion, while the use of YILI on dairy products could be regarded as well known, the goods under Class 11, such as hydrants, were sufficiently dissimilar to YILI Corp's goods, and that the opposed marks would therefore not cause confusion amongst consumers. YILI Corporation filed an appeal against the China Trademark Office decision with the Trademark Review and Adjudication Board, and the Trademark Review and Adjudication Board upheld the China Trademark Office decision. As part of their decision, they held that the opposed marks were for use in association with Class 11 goods, which were sufficiently different from that of dairy products on which the YILI well-known mark was used. In addition to this, the Trademark Review and Adjudication Board added that YILI was the transliteration of the Erie Canal in the United States, and therefore there was no unique connection between YILI and the well-known YILI mark. And for these reasons, the TRAB held that the use of the registration of the opposed marks for Class 11 goods would not cause confusion nor mislead consumers. YILI Corporation appealed the TRAB decision to the Beijing No. 1 Intermediate People's Court, which overturned the TRAB decision. And in coming to the decision, the First Intermediate Court considered the factors as enumerated under Article 10 of the Supreme People's Court interpretation, that is, the distinctiveness of the well-known mark, public awareness of the well-known mark amongst the relevant public, the relatedness of the goods bearing the well-known mark, and those bearing the disputed trademark, and other relevant factors. Looking at the distinctiveness of the YILI mark, both the Trademark Review and Adjudication Board and the court agreed that the YILI mark was a well-known mark with respect to dairy products. Both the Trademark Review and Adjudication Board and the court agreed that due to the YILI mark being well-known, the relevant public for Class 11 goods coming across these type of goods affixed with YILI or YILI imitation mark would be familiar with the YILI mark as used on dairy products. Both the Trademark Review and Adjudication Board also agreed that the goods were very different and that relevant consumers for goods bearing the disputed marks on Class 11 goods would not be confused as to YILI Corporation being the source of these goods, nor would they be misled to believe that there is a commercial relationship between YILI Corporation and the manufacture of goods in Class 11. Where this case, where the court looked at other relevant factors, such as the reputation of the mark, which the Trademark Review and Adjudication Board did not look at, the court considered that the reputation of the YILI mark was very high amongst the relevant public. And they also looked at this issue of inherent distinctiveness again, where TRAB came to the conclusion that there was no unique connection between YILI and dairy products. There was a potentially another possible meaning for YILI's being Erie Canal. The court held that this was at best a tenuous connection, such that YILI and dairy products in the minds of consumers far exceeds any other possible connection or meaning to YILI, such that you will not find many of the relevant public for these types of goods familiar with the Erie Canal. So, according to the Intermediate Court, due to the high reputation and distinctiveness of the YILI mark, consumers would inevitably associate YILI and YILI Corporation with any products bearing the YILI mark. In addition, the Intermediate Court held that the use of the YILI mark on hydrants would dilute its high distinctiveness as a well-known mark, such that the use of the disputed mark on sanitary apparatuses and installations would cause consumers to associate the YILI mark with something unclean and to its detriment. In addition to this, the Intermediate Court held that the high reputation of the YILI mark in China would be sufficient to lead YILI Corporation to believe that the applicant of the disputed mark had taken advantage of the high reputation of the YILI mark in the Chinese marketplace. And accordingly, the court overruled TRAB for the above reasons. The Trademark Review and Adjudication Board appealed their decision of the Intermediate People's Court to the Higher People's Court, arguing that the court applied the test for dilution or Article 9, Section 2 of the Supreme People's Court interpretation incorrectly. More specifically, the Trademark Review and Adjudication Board argued that consumer confusion must exist as a precondition prior to a dilution analysis being applicable. And here, the Beijing High People's Court disagreed with the Trademark Review and Adjudication Board, upholding the ruling from the Beijing Intermediate People's Court. In their opinion, confusion is not necessary. In looking at the test that is specified under Article 9, Section 2 of the Supreme People's Court interpretation, where it is sufficient to make the relevant public believe that there is a certain connection between the trademark against which the lawsuit is lodged and the famous trademark. This is sufficient for considering whether a well-known trademark should be provided with extended protection. So, looking at the facts of this case, the Beijing Higher People's Court came to the conclusion that there was a certain connection between the YILI mark and the trademark against which the lawsuit was lodged. And due to this connection between these two marks, the distinctiveness of the well-known YILI trademark would be diluted and its reputation would be degraded, as well as the fact that this other company would be utilizing the YILI trademark, the famous mark, improperly. And this therefore allows the well-known YILI mark to be entitled to a broader scope of protection beyond the goods that is normally associated with and those types of goods that are listed on the trademark registration for YILI. So, in summary, looking at the history of the development of this test for well-known marks, the fact is that cross-class protection for well-known marks is available in China. However, not all well-known marks are entitled to cross-class protection according to Chinese law and practice. And historically, this has been very difficult for us to explain to our clients, such that we did not have very much guidance from the Trademark Office or the courts as to how this test is applied. However, the Supreme People's Court have been more active in this area as of late, and they have introduced two legal instruments to guide practitioners and well-known trademark owners with regards to how to proceed to protect their well-known trademarks via a broader scope of protection for dissimilar goods and services. For civil litigation, we can point to the test as specified under Article 9 of the interpretation from the Supreme People's Court. And the same test may be applied in administrative litigation according to the opinion that was introduced by the Supreme People's Court just last year. Looking at in determining whether extended protection should be provided to well-known marks, the courts have mentioned three factors specifically. That is the distinctiveness of the well-known trademark, the public awareness of the well-known mark amongst the relevant public, and the relatedness of the goods bearing the well-known trademark and those bearing the disputed trademark. There are other factors that are not enumerated in the interpretation or the opinion, and these are covered in some cases, such as inherent distinctiveness, the reputation of mark, and other items that might not be as applicable for typical cases, such as historical and cultural issues, such as in the Xinhuacun case. And that brings me to my last slide. And if there are any questions, I'd be happy to answer them at this time. Thank you very much for listening in and for your patience with my dropping this call earlier.
Thank you. We will now begin a question and answer session. To ask a question, please press *1. Please unmute your phone and record your name slowly and clearly when prompted. You may withdraw your question by pressing *2. Once again, to ask a question, press *1. One moment, please.
If anybody's listening to the presentation on the audio recording, you can contact Dr. Chan at gchan@iprigHts.com.
And we show no questions at this time.
Dr. Chan, there was a question that was emailed in. The question asks, could you please identify please explain how one identifies a well-known mark?
Okay. In the Supreme People's Court interpretation, which outlines the test for determining the scope of protection for well-known marks, there is also a list of considerations that should be addressed prior to obtaining well-known status, and that is to prove well-known status, you'd show amongst the number of factors. One is under one heading you have the market share, the marketing region, the profit, and the taxes of the commodities using the trademark which you want to prove to be well known. The second is the length of use of the trademark. How long has the trademark owner been actively using this mark in China? Another would be the duration, extent, the amount of capital input into advertising the well-known mark or the mark that you want to prove to be well-known throughout China. Another factor that you would look at is the history of protecting this mark as a well-known mark in China. Perhaps there was an earlier case where the trademark owner was able to prove that it was a well-known mark. Another aspect that you'd show is the market reputation of the trademark in terms of, does it have a very high reputation, similar to the YILI case that we just recently covered. And there is also one section which is basically a catch-all for other factors that you might be able to rely on to prove that your trademark is well known.
Thank you, Dr. Chan. Again, we'd like to thank Dr. Chan for his presentation today. And if you have any questions on this presentation, he is welcome. He's welcome on emails. I just wanted to remind the listeners that next month, on October 11th, and again on October 18th, we have two presentations. The October 11th presentation is by Georgia's colleague who will talk about protection at trade fairs in China. And another Chinese practitioner will present on October 18th on licensing your trademarks. You can register at janice.wingo@trade.gov, or please get on the stopfakes.gov website. Operator, are there any more questions?
We show no questions at this time.
Well, George, again, we want to thank you for your presentation, and I suspect that you will have a few emails when people go back and listen again and ask you some more questions. Again, thank you again.
Thank you very much, Janice, for your assistance with this webinar. It was greatly appreciated.
Thank you for joining today's conference. You may now disconnect.